is Sandy Asper reporting for Costa Mesa Brief, and I have beside me John Caldecott, and we just got out of the Court of Appeals. Can you just briefly tell what this case was about and what the appeal was about?
To avoid HR speak, to be honest with you, this is about a bully who was running a school district. I took many steps to resolve basic HR issues. As a good employee and as an HR person, I pursued things that I thought was my job to ask questions about that could reflect poorly on the district. And you have to remember, the last superintendent before Navarro was fired because of a conviction of a felony. And one of the allegations was he told the payroll department to increase a stipend by $10,000. I'm pretty sensitive to what goes on in an HR office and in a school district. I raised these types of concerns to the superintendent, and I became the target of his bullying and his hostile working environment. He also had other components of the complaint involved other members of cabinet. The issues are significant, and that's why after the board determined, after no investigation, that they were doing nothing, that I went to the public and I attempted to get public records. Those public records tell the story. I don't need to tell it. If a patient member of the public is willing to look at the records, it shows how the district operates.
What you are going to be seeing are clips from the State Appeals Court in which John Caldecott is appealing the former court decision which denied making the documents that Caldecott wants to make public. As you will see, William Crosby, Caldecott's attorney, argues that the documents should be made public as they contain important information regarding some financial malfeasance and evidence of bullying on the part of the superintendent.
It wasn't unlawful. Well, doesn't the public have an interest in knowing whether the chief administrator of the school district just might be bullying or abusing employees? And according to Mr. Caldecott, there were 3 employees involved. And shouldn't the public have an interest in knowing if there was a waste of public funds or why this district director of HR was terminated when he raised these issues? And in these emails, he documents the hostile environment, acts of retaliation, and financial irregularities. And yes, he requests whistleblower status. And isn't that understandable, given that this district has a history of problems with high-level executives, and he was concerned about retaliation, and rightly so, as it turned out. There can be no accountability on the part of government or public officials without transparency. Having raised his reasonably based suspicions of improper governmental activity, Mr. Caldecott requested the records so that at least members of the public could make their own judgment. This court now has an opportunity to confirm that a public employee who has a reasonable and good faith belief of improper public activity takes a wise and judicious course if he or she has confidential documents by making a public records request.
Spencer Covert, longtime attorney for the district, argues that the superintendent might be tarnished by the documents, which are not important enough to be made public.
In none of the cases cited was it claimed that it was necessary to obtain these records for a formal CPRA request in order to shield the requester from litigation. There is nothing in the record to indicate the district or any employee ever posed litigation or threatened litigation if the records were disclosed. In all due respect, this is a red herring brought to protect what is a believed private interest.
Well, why should the employee have to take the chance that this will be the first time the district does it?
Well,
if he's already got it, and
then why not produce it?
Why not produce it?
Right. If he already has it, he can produce it,
Well,
and it could have been
what's your
produced.
problem with giving it to him again, or agreeing to give it to him again?
The problem with giving it then to him again is an analysis based upon 6253 and 6254. That's what the district said in its response.
Yeah, and that's what you're trying to avoid.
We are trying to apply an examination of 6254 and 6255 and determine whether or not the records should be turned over.
This distinction between concerns and interests and complaints, is your position just that because they're called concerns, they don't rise to an important level?
I think that is the first position, and the second position is that when you look at the cases are balancing the allegations that are made of misfeasance, malfeasance, sexual misconduct, or in the ASME case that was cited, a case in which there was an audit and audit findings against the district.
But by the same token, the fact that there aren't allegations of sexual misconduct reduces the interest on the other side, reduces the need for confidentiality. These are not allegations that a person has molested a 6-year-old. They're allegations that the law is being improperly interpreted.
Correct. And nevertheless, if I'm the superintendent or I am the deputy superintendent who has a version of how a proposed management schedule should look, by the way, not one that was adopted, but should look, and I am being accused of not following the law, that does have an important adverse interest upon me when I represent the school board in public meetings, when I deal with teachers, when I deal with community, because I now have a label over my head that I'm committing financial improprieties.
No, you have,
Well,
let's put it this way. If he had called this accusations instead of concerns, would that have increased the weight of his?
you have to, I don't believe that the label is important.
Well, you keep talking about it, these are merely concerns.
And which I believe they are, because once they are reviewed by the board, which the board had a right to review them, it was in effect much like a court looking at a general demur. These allegations that our hostile environment do not rise to the level of anything other than honest debate and differences of opinion between highly educated, intellectual, sophisticated, trained school administrators. You have to find that there's substance to that if you're going to allow this criticism to occur to matters which have taken place between high-level employees. The district had a discussion about that, and you see that in Martha Floor's declaration. They had a board meeting in which the board members said, should we make this public? They asked themselves that. They said no, because they believed the superintendent's reputational interest outweighed the criticism that was being made. So that is why I believe that under the exemption of 6254 personnel files, the private interest outweighed making those statements. If you're going to turn over these type of documents, then you're going to cause administrators to keep their thoughts to themselves and to return to their own smokestack decision-making. That is why the board, and I believe that there should be some deference given to the board, as to why it believed in non-disclosure. It's not just a simple thing, well, this isn't too serious, well, it speaks for itself. I think it's helpful to take it, by the way, from the beginning, because what you will see is it is the adjectives and adverbs that were used by Mr. Caldecott to describe his concerns that were elevated.
So what you've outlined to me is a series of terrible things that are going to happen if these things become public. So your position isn't, it's moot, he's already got them, and we're never going to do anything about it. Your position is if he reveals these, horrible things are going to happen. If horrible things are going to happen if he reveals them, why wouldn't you take action against him if he revealed them?
Well, I don't believe that's the correct analysis. The correct analysis is the horrible things that support the public interest in non-disclosure. The public interest in non-disclosure
But why are we then arguing about mootness? It isn't moot. It's important that he not be allowed to disclose these, is what you're saying.
I argued mootness because, according to the LA Unified School District, it says here, the public interest is minimal and has little weight if the documents are otherwise available to the individual. That was the reason for arguing why it was moot. That goes to a consideration of what is the weight to give to the interest in whether or not it overbalances the privacy interest under 6254 or the public interest in non-disclosure.
You said at the outset of your argument that the board has never come down on anyone for doing this, and there's no threat here that the board's going to do anything.
Absolutely, there was no threat. That perceived argument that something might happen to me, we're now a year out, has never occurred. There's not a single word in here or in the transcript that says there's any threat to this employee. It's a question not of threats, it's a question of balancing the reputational interest between the individual or the institution with the public's quote-unquote right to know.
But what I can't understand is if your interest is so great, why aren't you willing to fight for it?
How else should we fight for it? We fought for it by citing Mark and saying we've looked at the allegations, we've considered what you've had to say, and we don't believe they're of substance. There's no obligation in this balancing issue of making non-substantive issues public when you balance that with the reputational interest of the superintendent
Okay,
or the other administrators.
I see where you're going.
So the case really is, are these actual public records and should they be released? Isn't that the case before the appeals court right now, in a way?
That is correct.
Or am I,
They are reviewing the Superior Court's decision, and I heard many questions that I thought got to the root of the matter. It's not about getting the records because I already have them. It's about using the records. And that is why I took the professional approach of using the Public Records Act to access for everyone. So the public can determine, did the board act appropriately? Did the superintendent act appropriately? Transparency in government is what the California Public Records Act is all about.
so this really falls under exactly what I said, that are these records actually public? And Mr. Covert, who I tried to interview and wasn't able to, he refused to do that. So they had the opportunity to say whatever they wanted. But your response to what he said in court today?
Well, it was interesting because I thought some of the dialogue would have happened at the Superior Court level. There was discussion about actual individual records and overview of the Public Records Act, and all I've ever requested is that each record be reviewed to determine whether it's a public record. The district has not released one word of 94 pages in a public records request. I've seen the requests that come through the district. That has never happened. And I can assure you there are public records in that group.
So when he makes the statement that really it is a matter of hurting someone within the district, so it's a matter of private concern, that was his point, I think, or as opposed to public concern, then that doesn't resonate with you.
Well, the Superior Court judge said that he had an obligation to protect people's privacies, mine and the superintendent's. That is not the purpose of the Public Records Act. It is to give the public any records that qualify under that act to provide transparency in government and to hold government accountable for their actions. It's not about protecting people's privacy. So yeah, I disagree with that issue. And I will just say also, a superintendent signs on with the understanding that you will be scrutinized by the public. That's a guarantee. The board is elected by the public. How can these individuals have their privacy protected when they are public figures and elected public officials?
What is your interest in being here?
I was an employee of Newport-Mesa for 28 years, and I'm currently retired. And the last 12 years of my employment, I was the union president for classified employees. And what I want to see happen is I want to see some transparency in what the district does. We've always had that, and it appears we don't have that anymore. I went to that school district. My husband went to it. My kids went to it. And I have a love for it. And I want to see what's done right and correct. So that's why I'm here. I want to see it done right.
So what was your feeling about what went on in the courtroom today?
I think the judges asked some really good questions of both attorneys, and you know, if you're asking me how I think they're going to rule, you don't know. I think that Mr. Caldecott's attorney made some very good points, and I hope that they listen and realize that the public does have a right to that information. So that's what I'm hoping for.
Hi.
Hi,
So what's your name?
Marla Loffelmacher, former district employee, worked for John Caldecott for many years.
Marla, what is your interest in actually being here today? Through a very long time. What was it? We were here like, 3 hours, 3.5 hours, something like that?
Well, it's important that people know what's going on when your public dollars are being spent on these kinds of things. My past history with the district has been, we've always been open, and there haven't been the secrets. And this case proves to me that there's a lot of things being swept under the rug that they don't want the public to know. They don't want people to know how the money's being spent, and they don't want to know how employees are being treated. And to me, that's paramount for teachers, non-teachers, and administration.
Reporting from the State Court of Appeals, the Caldecott hearing just got out about a half an hour ago, and we interviewed John Caldecott and some interested parties from Newport-Mesa Unified School District. Sat through the entire hearing, have no idea, I have no idea, and I'm not sure that anyone else does either, how this is going to turn out. But it's going to be exciting, and this is definitely not the end. So reporting for Costa Mesa Brief. Thank you.